Good afternoon, everyone. My name is Teresa Murray. I'm the Civil Rights Policy Advisor at USDA's Food and Nutrition Service Civil Rights Division. It's my pleasure to be with you all this afternoon. I am here to present information about the new guidance that's been issued entitled Modifications to Accommodate Disabilities in the Child and Adult Care Food Program and Summer Food Service Program. Before we begin, I just want to remind everyone that at the end of the presentation, there will be an opportunity to ask questions. In the bottom left corner of your screen, you'll see a chat box. There's an opportunity to type in your questions, and at the end of the presentation, I will try to answer as many of those questions as possible. Also, we'll be able to make these slides available via the partner web, and we may be able to send them out to participants in today's webinar as well. The guidance that I mentioned, the Modifications to Accommodate Disabilities in the Child and Adult Care Food Program, or CACFP, and the Summer Food Service Program, SFSP, was just issued at the end of June, the 22nd of June of this year. And the guidance, as well as our training today, will provide you with important updates to the requirements related to accommodating participants with disabilities. The guidance just applies to CACFP and SFP sponsors, as well as CACFP institutions and facilities. I will refer to that entire group as program operators throughout this training, but it just means all the participating organizations in those two programs. The guidance did supersede FNS Instruction 783-2, Revision 2, and the new guidance is in effect as we speak. Before also we begin, I'd like to encourage everyone to sort of take this training with a bit of understanding that there are not a lot of clear-cut black and white answers in this field. When you're accommodating individuals with disabilities, the determinations must be made on a case-by-case basis. So our focus for today will endeavor to provide some guideposts and some guidelines and sort of rules to help you through that process. But bear in mind, there just really aren't definitive, concrete answers for every situation. They have to be looked at individually, and the analysis conducted based on the totality of the circumstances involving that particular person. So let's begin. The Civil Rights Division has a number of statutory and regulatory authorities. I won't go through them all today because I'll try to keep as much time at the end for questions as possible. But I've listed a few here. The ones that are bold and underlined, those are the ones we're focusing on today. Section 504 and the ADA and the Amendments Act of 2008 essentially are the umbrella laws that prohibit discrimination on the basis of disability. In 504, prohibits disability discrimination by recipients of federal financial assistance, and the ADA deals with certain types of entities, including state agencies. These statutes are sort of implemented by a sort of web of other authorities. Here I've listed some regulations, as well as the FNS 113, which I hope everyone is familiar with, which lays out all the civil rights requirements. There's an Executive Order 12250, which specifically pertains to disability, as well as 28 CFR 41, which is DOJ regulation, that's Department of Justice, which is a government-wide regulation pertaining to Section 504 of the Rehabilitation Act. As I mentioned, the disability law is sort of a cobbling together of statutes and regulations, and basically the whole framework of the requirements are derived from Section 504, ADA, the implementing regulations, as well as policy guidance. And the policy guidance is, of course, the focus of today's training. In that set of requirements is a duty to provide reasonable modifications. Again, there isn't a clear-cut, definitive sort of set of rules with respect to what modifications to provide. That all is sort of nebulous, and it has to be dependent upon the circumstances pertaining to that individual. Section 504 and the ADA are essentially mirrored statutes. 504, again, pertains to recipients, and ADA Title II is for public entities, including state agencies, local agencies, and Title III deals with public accommodations. At the outset, I'd like to sort of remind everyone that as long as an entity receives $1 of federal financial assistance, they are required to comply with a whole set of requirements under Section 504. And federal financial assistance is not just money. It could also be federal staffing that's provided to a state. It can be equipment. So anything that under regulation is considered federal financial assistance, that brings the entire operation of that organization under those requirements, not just the part that's administering the program, but the entire operation of the organization is covered. Okay. The ADA Amendments Act of 2008 is the impetus for this guidance, as well as the parallel guidance that was issued for school meals. It is an important statutory change because the courts have construed the prior sets of requirements under the ADA somewhat differently than what Congress originally intended. So the Amendments Act sort of expanded and clarified a number of things, and chief among those is the definition of a person with a disability. The actual statement about who a person is that's covered under the statute hasn't changed, but what each part of that definition means has been changed by this statutory amendment and has been expanded significantly. The Amendments Act did not change the expectation of recipients of federal financial assistance or others covered by the ADA from providing a reasonable modification as well. It also made clear that the focus should no longer be on sort of figuring out or analyzing or spending a whole lot of time trying to figure out if that person really has a disability. The focus now should be on what the recipient or program operator can do to accommodate that person. That is a major shift in how things had been in the past, where we spent a lot of time figuring out whether they were covered or whether it really meets the definition or whether their condition is severe enough such that they would have the protection. That's no longer the focus at all. The focus is what can the program operator do to make sure that that person who has a disability is able to equally participate and equally benefit from the program as any other person. That's now the focus. Okay, the definition of a disability is on your screen. I won't reread it, but suffice it to say the phrases that have been underlined, that's what the ADA Amendments Act expanded. What exactly is a physical or mental impairment? That's significantly broadened. Substantially limits. Courts have previously construed that as almost prohibitive. The statutory amendment made clear that it's just an impact on a major life activity that's important. And exactly what may constitute a major life activity, that has been significantly broadened by the statutory amendment as well. So there's three categories. First is just someone who actually has a physical or mental impairment. So that's someone who is currently suffering from that limitation in such a way that it affects their major life activities. The second category is a person who has a record of or somewhat like a history of an impairment. So if someone had a condition and they had surgery, for instance, and they no longer suffer from that kind of impairment, they still are covered because they had a record of it or history of a condition that impaired a major life activity. The third category is a person who is regarded as having an impairment, and we call it just that, regarded as. And that's someone who really does not have an impairment, but is perceived as having one and is treated as such. One example of that is if someone is believed to have HIV and they really don't have HIV, but they're treated discriminatorily because they're thought to have it when they really don't. Or if someone had an overseas trip and they come back and they're coughing and they're being treated as if they have a communicable disease or some other condition when they really don't have that, that is this third category here. And that group of people are, again, covered as a person with a disability by statute and by regulation. The third category, though, is not entitled to a reasonable modification, but the first one certainly is, and the second category may be depending upon the circumstances. If you remember, substantially limits was underlined in the definition. That's been expanded as well under the new statutory amendment. There is no longer a need for the impairment to prevent or severely or significantly restrict a major life activity. It just needs to impact it. Also, again, the individualized assessment must be the basis for any decisions about whether someone is entitled to reasonable modification or whether they are considered covered under the statute. That has to be based on the particular circumstances of that individual. The Amendments Act also made clear that any mitigating measures should not be considered when determining whether a person has a disability. So if someone has a condition for which they take medication, for instance, they should not be considered in their medicated state. Even though that condition may be controlled, they are still considered a person with a disability, and they must be sort of looked at or evaluated in terms of determining coverage based on their condition without that mitigating measure being in place. Also, the Amendments Act made clear that impairments that are episodic or in remission also are considered covered conditions. And in the past, there was a question about that, but now it's really clear. So if someone has cancer, for example, that is in remission, that isn't sort of affecting the person at the time, that doesn't matter. That person is still considered an individual with a disability protected under law. The last significant change that was put into place by the Amendments Act is a whole new category for major life activities. Previously, the major life activities were just simple, major sort of everyday things that people do: seeing, hearing, walking, speaking, eating, breathing. The statutory amendment added a whole other category of major bodily functions under that part of the definition. So if someone has an impact on any of these functions, then they're considered a person with a disability. And I just listed some of them there. Digestive or respiratory come into play pretty frequently. So if there's an impairment that limits any of these major bodily functions, that person is now considered a person with a disability entitled to protection under law. Okay, we've included this slide here just to remind participants that if there are other considerations outside of a reasonable modification, they have to consider the whole gamut of their responsibilities, the program operator's responsibilities under disability law. So here are sort of 4 types of disability discrimination that's listed on the slide. First is discrimination because of the disability. That's intentional, what we consider intentional discrimination, right? That's when someone is denied a benefit or an opportunity to participate because they have that impairment, or they're segregated because they have a disability. The ADA and Section 504 go even further, which is somewhat different than some of the other anti-discrimination statutes, where it specifically outlaws aiding, perpetuating, or contracting with anybody else who may be discriminating. So you can't have a contract or arrangement with someone else where they actually deny benefits to individuals with disabilities or et cetera. That is a specifically prohibited activity. Failure to provide a reasonable modification, that's the focus of our training today. And ineffective communication in inaccessible facilities. Both of these sort of categories are almost fields into themselves. Effective communication is a responsibility that every program operator has to communicate with persons with disabilities in a way that is effective for them. So if a person has a vision impairment, for example, they may need program materials in a different format. Maybe they need something read to them. Maybe they need it in larger font or Braille. That's one example of effective communication. There's a whole set of standards and requirements that pertain to that, and we're just reminding state agencies that that requirement is there. That's outside of their training, but that is another form of disability discrimination if the communication is not effective. Also, accessible facilities is obviously required. I'm sure everyone is well familiar with that. But again, the standards that are required for ramps or elevators or heights of different things, there's a whole set of rules and requirements related to that that is, again, outside this training, but we want state agencies to remember that this isn't the whole thing that we're talking about today, that there are other aspects to compliance with the Rehabilitation Act and the ADA. Okay, so we'll focus now on the guidance. Again, it was issued the 22nd of June. It just pertains to these two programs, and a copy of it is available on our website, and the link is provided here. Okay, so what is a reasonable modification? It is any change or alteration in policies, practices, and or procedures to accommodate a person with a disability. Essentially, that just means anything that you normally do that you may have to change how you do it or when you do it or where you do it, that's a reasonable modification. And that is required for individuals with a disability. I'll give you a couple of examples. We should all be familiar with the meal pattern requirement to provide milk with meals. That's a policy. But if someone has an impairment where they cannot consume milk, or when they do consume milk, they have an allergic reaction, it affects their digestive system or their respiratory system, they are entitled to a modification of that policy and entitled to a different beverage besides milk. And there are a number of alternatives, but I believe we are encouraging, obviously, program operators to replace it with a nutritionally equivalent item. But that's just an example of a policy modification for a person with a disability. A practice modification may be a change to your service meal times. You may serve meals, let's say, between 11 and 2 under SFSP or something. You may need to modify that if a person with a disability needs that to be changed in some way. Or if you serve at specified times, they may need more frequent meals, or they may need it at a particular set time. That may be a modification that may be required. In order to arrive at what reasonable modification to put in place, program operators should dialogue with the participant or their representative to figure out what makes sense for that person, to figure out what exactly the barrier is or what the limitation is, and brainstorm about what modification could be put in place that would allow them to benefit from the program and participate in the program just like any other person who does not have a disability. And that sort of duty to engage in that dialogue and negotiation really means that there shouldn't be a knee-jerk no to any request. It should, when you receive a request, it should be an opportunity or invitation to have a discussion. So program operators shouldn't initially just reject the request. They have to engage in a discussion about what may work for that individual. The primary objective of that discussion is not to sort of figure out, does this person really have a disability, or how severe really is it, or what are we talking about here in terms of whether they really need this or not. Again, after the ADA Amendments Act, that is no longer the focus. The focus is on what modification should be put in place for that person. And again, that determination is on a case-by-case basis. There isn't a one-size-fits-all where everyone with that condition, this is what you're going to do. It has to be based on the facts and circumstances of that particular individual. A couple things about the modification itself that will help guide the dialogue and the decision about what modification to put in place. First, the modification should be related to the disability or limitation at issue. If an individual has a vision impairment, then perhaps they should receive, as I said, a larger print menu. They should receive something in Braille or in a different format, but they wouldn't necessarily be entitled to a different type of meal or a substitution of an item in the meal, because that's not really related to their impairment related to their vision. Also, the modification that is requested doesn't have to be the one that's ultimately provided. As long as there is a modification that's put in place that's effective to allow that person to participate, that's adequate. If our office receives a complaint in this area, that's what we're looking at. We're not looking at whether or not a program operator provided the modification that was requested. It's whether the one that was provided was reasonable under the circumstances and addressed that person's limitations or any barrier to their participation. So typically, brand name items don't have to be provided. The only exception with respect to that is the infant formula. If a healthcare provider prescribes a particular formula, that is the formula that should be provided to them. Outside of that somewhat limited circumstance, any other brand name item doesn't need to be provided to them as long as it meets their needs. That is adequate. Generally, the modifications should be provided free of charge. There are two minor exceptions to that, but for the most part, they should be provided to the participant without any additional fees or costs or surcharges. Lastly, if through dialogue and discussion or maybe multiple efforts to discuss the issue, the parties just don't agree. The participant or representative wants one thing and the program operator doesn't agree and they think something else is adequate. It doesn't require agreement. Implement the modification that the program operator believes should be put in place. To do nothing is where you might get in trouble with my office. So if there just isn't agreement, that's fine. Just put what the program operator thinks is appropriate under the circumstances in place. And if the individual wants to continue to pursue other avenues, that's fine. But as long as something has been implemented to address their limitation, you should be in good shape. Some other key considerations to help guide this process of arriving at a reasonable modification. First is consider all the costs and resources that are available to the state agency or the program operator. Again, it's the entire operation, not just the portion that deals with the program. So all of the resources available to that entire organization is what a court will look at to determine whether or not there was enough resources or money available to provide that modification. Also consider the participant's age and ability. Some individuals are able to manage any modification themselves. Sometimes it's just, okay, when it's mealtime, you're going to pick up this item and not that item. However, if the participant is of an age or an ability where they can't manage that themselves, then there may be a need to think about an alternate modification or some sort of aid or assistance to make sure that that modification is available to them and that they are able to implement it and use it within the program. Secondly, reminder here is stereotypes should have no place in this process. And what do I mean by that? I mean that don't bring any sort of outside thoughts, opinions, and views about a condition into the assessment and the decision. All of the decisions must be based on the facts of that particular individual, not based on what your experience is with it or what you know about it. Thirdly, meal accommodations don't have to mirror the meal item that's substituted. So if there is pizza served on Friday and one of your participants is allergic to cheese, the program operator doesn't have to go out and find a cheeseless pizza. It's okay to give the person another item, a sandwich or salad or something else. So you don't have to worry about that being an exact replica or substitute for the item that the person can't consume. Lastly is lifestyle choices are not required to be accommodated under law. So if someone is deciding to go vegan or vegetarian or make other choices because it may be, in their mind, better for their health, that still does not rise to the level of a disability because it's not related to an impairment. It is their choice, but it is something that, by law, doesn't have to be accommodated. Okay, so there is an exception to all of this, to this duty to provide a reasonable modification, and that is modifications that require fundamental alteration to the nature of the program. If the modification requested would cause undue financial burden on the program, such that it would essentially cause the operation of the program to cease or just no longer be able to operate, that modification does not need to be provided. So that is a significant exception, but it is a narrow one. It should very, very rarely be the case. And there's two caveats there. That's why there's the caution symbol there. One is, let's say that someone requests something and there's just, and you dialogued with them and you brainstormed and there just really isn't a way to provide the modification without significant cost, where you would essentially not be able to continue to operate the summer program, let's say. If that happens, we are encouraging program operators to consult with FNS or with the state agency, if they're a local operator, before using this exception. Certainly in my office in FNS, we'd like to provide technical assistance before anyone is told no, because sometimes we just have some insight or some thoughts that may be helpful, or we may just be able to guide you into some form of modification that may be adequate. Also, the other caution is that, let's say that you have to use this exception and deny a modification. That doesn't mean that that person should be excluded from the program or that they should somehow be denied other benefits or services under the program. That will rise to the level of violation potentially. Okay, the topic of food allergies. We received lots of questions about this in my office, and we hope that this training and the guidance will help address some of these. Food allergies, essentially, everyone has had sort of somewhat of an experience with it, but under the new statutory amendment to the ADA, I will just start out by saying they're covered. Previously, there was a question. There were certainly some instances where we weren't sure whether that would be covered by law, but with the new statutory amendment, 99% of food allergies are going to be covered. Food allergy is just any adverse health effect arising from a specific immune response that occurs when someone is exposed to a particular food. And whatever that immune response is, now it'll probably impact one of those major bodily functions and will be covered under the statute. We've listed here in the first bullet some information provided by the CDC. They indicate that 90% of serious allergic reactions really all boil down to 8 food or food groups, and they're provided here. And we listed them here so that program operators, state agencies, that they're aware of what these are, so that potentially that you can game plan about what substitutes you may offer instead if someone comes in needing a reasonable modification. So if you're serving breakfast and you're serving eggs sometime during that program, there's chances are someone may be allergic to eggs. So to think about ahead of time what substitute you may offer for eggs is a good idea. We essentially think that most of the allergic reactions could be sort of prevented if some pre-planning is put in place. Also, a reminder that the statutory amendment made clear that the allergic reaction does not need to be life-threatening. It doesn't have to be really severe. If it just impacts a major bodily function such as digestive or respiratory, that is sufficient to bring that person under the coverage of the statute. Some other key considerations with respect to food allergies. We receive questions quite frequently about whether to have what we call universal exclusions of food. And I'm sure most of you have heard of individuals or organizations indicating that they're a peanut-free environment or as such. It is FNS's policy neither to encourage or discourage that. So we don't say that you cannot do it, and we don't encourage that you do it. We just say keep in mind that if that is what an organization purports, and that's what they represent to participants, that they have to think about whether they can consistently keep that allergen out of that facility. Because if someone comes in with a candy bar or something at night, or somebody in a cleaning crew or some other entity or organization that shares the same facility, if you can't sufficiently control access and what goes on in those facilities, you might want to think about whether you would be able to make good on that guarantee that that environment is free of their allergens. So we just want individuals to keep that in mind as they think about whether to have universal exclusion. Okay, program accessibility. We have this slide here just to sort of broaden the scope a bit about what may be a reasonable modification. So sometimes a modification may just be changing how you do something or when you do it. But there's also a subset of requirements related to the provision of auxiliary aids and services. So sometimes a modification is an affirmative duty in that you must make sure that that person is able to participate and enjoy the meal like any other person. So they may need an aid, they may need adaptive feeding equipment, they may need help tracking their meals, for example, if they have diabetes. So sometimes it's not just changing something, it may be something in addition that you are required to do. And of course, all food service areas must be accessible. It can't be any barrier to access to the place where the meals are being served. So as we segue into integrated environment, we've already discussed what a reasonable modification is. We talked about how to arrive at it, right, through a dialogue or discussion with a participant or their representative. Now we're going to talk about where the modification should be provided. Section 504 specifically requires that individuals with disabilities be served or participate in a program in what is called the least restrictive environment or the most integrated environment possible. And if you think about it in terms of race, it will help. So we can all pull on our history here where there used to be racial segregation where they would say, okay, this is the category that you belong to. You can only go here or you can only go there. The same is true for disability. There shouldn't be a separate place for those participants to be. They shouldn't be ostracized in any way. That is specifically prohibited by 504. We do understand in the food allergy context, though, that can be a little challenging if there's someone who particularly may not be able to manage what goes on around them exactly, or the meals that others who are eating consume, and it may somehow get in their space, or somehow there's some sort of cross-contamination. We do understand that there may be a need to somewhat separate the person, particularly if their allergic reaction is severe. So we just recommend that program operators sort of endeavor to strike a balance between safety and stigma. So perhaps there is a bit of a separation, but it doesn't necessarily have to be a whole other part of the facility or a whole other room altogether. It might just be a different table, for instance. Just if that area is used for a person with a disability, to ensure that that is also not in any way seen as a disciplinary action or somehow negative to the extent that you can control it. We are encouraging program operators to think about potential stigma that may go along with that modification. So just some things to think about there. Okay, so you've heard a lot of what the requirements are, and again, what a reasonable modification is, how to arrive at it, and where it should be provided, and how it should be done in a particular circumstance. This is a slide about the implementation and compliance. First, the program operators should develop procedures for parents and guardians and participating adults and their representatives to request the reasonable modification. They should train their staff and volunteers on what a reasonable modification is and exactly what the requirements are under law, as well as in the new guidance. Also, program operators should appoint a person to provide technical assistance on reasonable modification matters. Just someone who sort of oversees and coordinates compliance with this area is what that person's job should be. It doesn't have to be a new separate hire. Just someone who has that as an additional set of responsibilities will be sufficient. FNS is recommending that program operators assemble a team to implement the guidelines and render decisions on modification requests. It could be a team that you all just decide makes sense. It could be someone from a sponsoring organization. It could be a site manager for SFSP, someone who would be able to be familiar with the guidelines and make sure that it's consistently applied, and that modification requests are responded to quickly and appropriately. And a word about medical statements. So you receive a request, you got procedures in place, everyone's trained. What can a program operator require in order to substantiate that request? They can request a medical statement. And the statement should just provide enough information about what the impairment is, how it affects that person's diet or their meal consumption, and how to address or accommodate that condition. The statement does not need to contain a diagnosis of DSM-4 code or any additional information. It's not necessary. If the statement is in any way inadequate or you can't read it, program operators should just seek clarification instead of denying the request. Go back and ask for the missing or unclear information. And while you're doing that, while you're obtaining clarification, if there's a part of the medical statement that is clear, abide by that and implement that while you're awaiting the additional piece of information. An example would be a medical statement that says Johnny has a medical condition which prevents him from consuming eggs. When he consumes eggs, he goes into respiratory distress. The statement, however, doesn't say what he should eat instead of eggs. While you're going back and finding out what items should be substituted, meanwhile, don't serve Johnny eggs. It's pretty clear he shouldn't have it, and what will happen if he does have it. So that's what we mean by that. The medical statement can be written by anyone authorized by state law to write prescriptions. Also, no additional requests should be made for medical records or charts or any additional lab results. Nothing outside of the statement should be obtained or requested. Lastly is that medical statements can always be requested and required by program operators. However, if the meal substitution would keep the meal within meal pattern, doesn't take it outside of the meal pattern requirements, it's still an easy swap. You don't have to obtain a medical statement to support that request. And here's just a brief graphic to explain the three basic components of a medical statement. And we're using a food allergy example. One, the food to be avoided. Again, Johnny can't consume eggs. A brief explanation of how exposure to that allergen will affect the participant. If he consumes eggs, he will go into respiratory distress, or it affects his immune system, or whatever it is. And then the third, which has an asterisk by it, if we allow program operators to go back and ask what substitute makes sense. But if it's missing from the statement, it doesn't mean the statement is inadequate. It just means that's a signal to go back and obtain the additional piece here, the third item. Procedural safeguards. This is sort of, as it says, these are some safeguards that must be put in place to make sure that individuals with disabilities who feel as if their rights are been infringed upon, or they are not really getting the cooperation they believe they should to obtain a reasonable modification, they are entitled to some basic things. First is notice. If an individual needs the notices that I'm going to discuss in different formats or different languages, because they have a different primary language, those notices should be provided in those alternative forms. But the notice should have, one, the process for requesting modification, information that assures them that any decision about their request will be provided to them in writing, the non-discrimination statement, which hopefully all of you are well familiar with, the NDS, and that the services are open and accessible to persons with disabilities, and also a notice of any location of accessible facilities. Let's say that the around back of a facility or a building is where there's an opportunity to access the building using ramps or elevators or a door assisted with technology, et cetera. The notice should provide them information about where and how to access the facility safely. If program operators have 15 or more employees, they must do a couple more things because they're larger entity. One is to designate a Section 504 coordinator. If you remember, I said appoint someone who would ensure that reasonable modification requests are handled appropriately. This is a similar requirement. However, this is a person who really has to coordinate everything. They have to coordinate the development of the procedures, coordinate all decisions, coordinate compliance, coordinate any notice requirements. They have this whole set of responsibility to ensure that the guidance requirements and legal requirements are followed. And lastly, if you have 15 or more employees, there must be a grievance procedure that allows for the prompt and fair resolution of complaints. So if an individual with a disability wishes to file a grievance or a complaint with the state agency, they must, or program operator, if they have 15 or more employees, there must be some avenue for them to do that. And once they submit that, they have to have the ability to submit any documentation or argument in support of their complaint and receive an opportunity to have a full understanding of the decision rendered in response to that complaint. So that's essentially putting the decision with respect to their complaint in writing. So now we have time for questions. I apologize we got started a little late, so I'm willing to go a little over just to answer as many questions as I can here. Okay, I see a question here that says, who determines the disability? Medical authorities with prescriptive authority in the state, a parent or guardian, adult participant. I'll answer it as best I can given the new statutory amendment, which is not the program operator. That's no longer part of your responsibility. If someone comes in with a medical statement and they say this person has this condition or they cannot consume this item, you have to sort of take it at face value. It's no longer part of the analysis to try to ferret out whether someone is being candid or they're trying to game the system. I know that may occur, but that is no longer part of our responsibilities now. It's just to provide a modification to them upon request with medical statement and support. If a parent or adult participant represents that they have it, again, you have to take it at face value, and any request for modifications, a program operator can ask for a medical statement and support. Even if they have questions about it, they can still just ask for the medical statement, but once they have it, that's pretty much the end of it. And I know that isn't necessarily a comfortable answer, but that's where the law is at this point. There's also a question about if a substitution, such as an expensive formula for PKU, is required and not financially reasonable, is it required to accommodate it? That's back to the fundamental alteration exception. First, because it is an expensive infant formula and it may be prescribed by name, that is something that's the request, that's the accommodation, the modification that would be at issue, and that's the one the program operator should examine. If providing that modification would be so unduly financially burdensome that it would essentially put the program out of business, they wouldn't be able to continue to operate, they would not be required to provide that modification. But before saying no, or before saying no, you can't, we're encouraging you to reach out to your state agency, the program operators to reach out to the state agency to reach out to us, so that we can make sure that before a no is given, that all avenues have been explored and that this legal exception is being properly applied. Is it permissible to ask for proof of disability? That's back to the question before. The only proof that you could ask for is a medical statement. And if the medical statement says that they have that condition, that is the end of the program operator or state agency's inquiry. Question about a reasonable modification. It's pretty detailed. I'll follow up with you on that one. Am I really advising program operators to contact FNS instead of the SA? I'm just opening the door to let you know that we are available, but if sort of the protocol is for you to contact the state agency first, and then the state agency, or perhaps together, you contact FNS, that works for me as well. I do have Rachel on the line, and she may be able to chime in about that. But again, our office is available, Civil Rights Division is available for technical assistance. There's a couple questions about those two exceptions of when you can charge a fee. One has something to do with educational institutions, and it's too detailed for me to get into on this training, but if it's an educational program, there is an exception there, and I mean primary objective of the program is to provide education, not just sort of additional nutrition education on the side. That has to be the primary objective and purpose of the organization. And there may also be an opportunity to charge a fee if we are really in the realm of fundamental alteration. So one of the things that, and I'm not saying this applies across the board, so please do not apply this exception without F&S involvement. I am just saying that this is, you're asking for what the exception to the exception is. This is what it is. So there may, if we're talking about some really expensive items that would put the program out of business, then there may be an opportunity to share some of that cost, but there are, again, so many considerations that have to go into that, and it may not, and it probably won't, apply to the situation. It is a very, very narrow exception, and I even hesitate to share it with the group today because the state agencies and program operators should not be applying it. It is a very narrow legal exception, and again, if you really think it does apply to your particular situation, reach out to your state agency and reach out to us. It's really our office who would like to weigh in on that because ultimately we'll hear about it. We'll either find out about it through a compliance review or ultimately a complaint potentially. So it's better to do the sort of the work up front rather than having an investigator contacting someone about a complaint because at that point it's already happened and we can't really help you. At that point we can do some corrective actions, but if a violation has occurred, it's already occurred. Read through the questions, bear with me. Okay, there's a question about, I guess, somewhat of the potential overlap of this guidance and the guidance dealing with school meals. And it's a specific question about page 4 of our policy memo, saying there may be additional requirements for basically a program that operates in a school. Again, I would feel more comfortable answering that with the particular circumstances, but I will give a general answer, which is if you're operating in a school or in a school meals context, the additional requirements that pertain to schools is they have a whole other set of procedural safeguards. It's significantly different than the procedural safeguards for CACFP and SFSP, even the 15 or more employees ones. You may be familiar with it if you're already familiar with the IEP Section 504 process, that whole procedural safeguard process. That's what would come into play in the school context. So that is a significant difference there. And the fundamental alteration exception doesn't even apply in the school meals context. No court is going to say that a school system does not have enough money to provide a modification. So that exception is really just there in theory for organizations as large as a school system. There's a question about whether the slide dealing with medical statement is applicable to CACFP. Again, if the modification pertains to a meal or meal substitution that does not take the meal outside of the meal pattern, you do not have to request a medical statement. You are always authorized to request one, but you don't have to. If it's going to still meet meal pattern requirements, you don't have to ask the person or their representative for it. Other than that, if you do request it or if it is outside of meal pattern, you must, in order to be reimbursed if it's outside meal pattern, request a medical statement, and that would apply to CACFP. Does the 15 or more employees rule apply to all daycare center staff? If it's 15 or more employees employed by the daycare, yes. So there's just two additional requirements. If you fall within that category, again, with respect to the designation of a 504 coordinator, as well as a grievance procedure. Does religious meal restrictions fall under the category of life choices? Good question. I'm not going to say that's a lifestyle choice. I'm just going to say that if it's a religious meal restriction, there's separate guidance on that, and I'm not going to necessarily promise that there's going to be a revision to that guidance, but we have gotten these questions frequently, and we do know that there's a need for some clarification information out there, but religious preferences, program operators are encouraged to accommodate them where possible. However, if it takes it outside of meal pattern, if the modification would do that, you do need a medical statement. So I can say simply that program operators are free to accommodate religious preferences, but if you want to be reimbursed for a meal that's outside of meal pattern, it would have to be a disability-related condition for which you have a medical statement. Someone is asking, is this grievance procedure, I assume it's the grievance procedure for organizations or entities with 15 or more employees, is it different from a civil rights complaint? Yes, somewhat. It is not so if you receive a grievance from a participant under your grievance procedure, our office wouldn't necessarily investigate that unless or until the participant indicates that they want our office to do so or submit a copy to us to investigate it. And we have a process for where they actually sign a consent form for us to actually investigate the complaint. So the idea, one of the ideas behind the grievance procedure is to allow the program operator to sort of cure and correct and address issues promptly. So that as soon as a grievance is filed with your organization, you know that that person believes that they should have a different food item or that they need assistance with tracking meals or whatever their modification is that they're seeking. And that is yet another signal to discuss with them what modifications should be put in place. If it's something where it's not related to that, it's just related to just generally they feel like they have been discriminated against based on their disability, that's when we're closer to the line of a complaint. It's not that they're putting you on notice that they want something or something's not going the way they think it should. And I'm not trying to belittle the complaint. I'm just saying that it's more on that level. That is something the program operator should deal with. If it's just a general complaint where they feel like they suffer disability discrimination, I would encourage the program operator to treat that like a discrimination complaint and civil rights complaint and follow the procedures that they have in place for that and making sure the state agency is aware of it. Again, if there's a question about whether it rises to that level or not, I would encourage program operators to reach out to their state agency, certainly to our division, and we can help clarify that if necessary. Okay, there's a question about a request for almond milk when the individual is saying they are lactose intolerant. Can they offer an alternate reasonable modification of lactose-free milk or soy milk. Can they provide almond milk and still claim the meals even though that is not nutritionally equivalent? I will allow Rachel or Andrea or someone from the program staff to address nutritional equivalence, but in terms of the reasonable modification, obviously, if they're saying they're lactose intolerant, you can ask for, what do you mean by lactose intolerant? Does that mean that if you consume it, it affects your stomach, or if it affects your digestive system, which can be presumed. You don't have to ask, but if you want to seek clarification, you can. And if they're saying it hurts their stomach, that is a major bodily function, as is your digestive system. That would cover them under the statutes and regulations. So if they request almond milk, again, they would not be entitled to a specific brand or a specific kind of milk unless the doctor is saying that this whole category of the type of milk has that impact on that person. Outside of that, if it's just they can't have cow's milk, then no, you don't have to provide almond milk. You certainly can if you would like to. We're not saying program operators have to do that, but you are not required to provide the reasonable modification that's requested as long as it addresses the limitation, which in this scenario is perhaps the inability to consume cow's milk. As long as you offer a nutritionally equivalent beverage, then that would be sufficient. Again, I'll rely on program staff to answer more specifically about the types of milk. That's sort of outside my purview of civil rights. Yeah.
So hi, this is Andrea Farmer. Thanks, Teresa. I'll jump in and talk a little bit more about the milk. So we do have provisions that if a milk substitute is nutritionally equivalent to cow's milk, which basically in practicality is about maybe 4 or 5 brands of soy milk that meet those requirements, that those can be served upon parent or guardian request. It does not have to be through a medical statement. So that's longstanding policy that we have already. Almond milk is not nutritionally equivalent to cow's milk, so it cannot fall under that category, and it would have to be, if it was going to be served, because it's not a creditable milk that meets meal pattern requirements, then it would have to be served as an accommodation and then would require a medical statement such as Teresa has been talking about. And just a little aside thing about the lactose intolerance thing, lactose-free milk is actually considered a fluid milk, and it can be served and does not even need that's not something that needs a medical statement because it is basically milk. So that could be at the option of a provider. If they wanted to provide lactose-free milk for somebody that was having a lactose intolerance, they could do that, and that's a reimbursable milk, and nothing would be needed. So hopefully that answered a little bit more.
I appreciate that, Andrea. That's certainly outside my purview. Thank you. I'll take 2 more. There are lots of them, and I'm sorry if I can't get to everyone. There is a question of whether parents can provide a substitute and whether an agency can require that the parents provide a substitute. First, parents can always provide substitutes. I mean, if that's what the parent wants to do for their child, or they certainly can. But whether an agency can require that is a little thornier issue. Again, the only way that, well, let me back up. If there's a dialogue and let's say an agency says, here's what we're going to provide. We're going to provide this type of milk, and they really want almond milk, and you just don't agree on the milk, for instance. If they want to bring in almond milk, that's fine. But can an agency say you must bring that in? No. If there is the fundamental alteration exception, again, it is not something that state agencies or program operators should sort of arrive at quickly. It really should be after exhausting every other option and technical assistance obtained. But if that is the case, then I would encourage the program operator to go back and explain that and have a discussion with the individual, the participant, or their representative about why that alteration applies. Again, those decisions should be in writing. So you have to sort of remember that whatever decision that you're making, especially if it's a no, it's going to be put in writing. And if there is a complaint, that writing will be part of the investigation. So if you get to that point where it looks like the fundamental alteration applies, and you come back and you explain that that modification cannot be provided, that is an opportunity to discuss what could possibly work as an alternative. So it may be that the individual says, well, if you can't do it, how about if I do X, could you do Y? You're certainly free to do that. But could you say to that person, you must provide this modification? No. So I just, again, we're on the fringes when we're talking about fundamental alterations, and I want to encourage everyone to remember that some modifications should be provided, something that's reasonable and effective for that person. It will be a rare thing where there's nothing that can be done, and you just have to tell the person no. So I just want to reiterate that once again. Can an accommodation outside of meal pattern be made without a form completed by a medical authority? I may toss this back over to Andrea, but my understanding is that for purposes of reimbursement, you do need the medical statement, but I don't think there's anything prohibiting some program operator from doing it. They just may not get reimbursed, but I know that may occur, particularly if there's a religious preference or some other modification that they're trying to make to make sure that people have equal opportunity to participate in the program. So I guess it's just the flip side. If you want to be reimbursed, you must have a medical statement if the meal will be outside of meal pattern. However, if there's no requirement that or prohibition against you serving a meal outside of meal pattern, that's not the case. Andrea, I don't know if you want to weigh in on that.
That is exactly correct.
Okay.
Thank you.
Okay. Again, I thank everyone for participating. I know there are so many questions that I was not able to get to, and perhaps we'll figure out some way to either answer them or, I don't know, perhaps make available another training. I'm not sure, but I do really sincerely appreciate the interest in the questions, because that means that you're familiar with this area and that you really you know how this can really play out in real time, and I value that as well. I have put up on the screen my contact information. Again, if there's protocols with respect to state agency first or program first or what have you, please follow those. I'm not trying to encourage that, line jumping or anything. I'm just offering, as our office always does, technical assistance pertaining to civil rights issues and disability discrimination issues. My understanding is that this webinar, including the Q&A portion, will be available, and it's being recorded, and it will be available on Partner Web. And again, the slides will be available on the Partner Web and may also be shared with the participants. So I thank everyone for their time today. And again, reach out if you have additional questions. Thank you very much.